Ready?
Yes, yes, you are.
Get control.
And Judge, for the record, I want to point out I was an hour off, and that's it.
A whole hour?
That's it. I was an hour off on my timing.
That's common around here. I'm used to it.
I just want you to know that.
I don't hold it against anyone.
I told her Saturday was
3 what?
Hours.
hours.
I said 2.
And it was turned out to be 3?
I believe so.
That's why Ms. Bolt is in charge.
I am going to get Dr. Ewing out today, though.
And I appreciated that optimism earlier.
Did we have to sleep here?
Well, Mr. Terry has a commitment that he told us about, though.
No, I know. I'm 5:30.
All right.
Or no,
5:45.
5:45.
But let's not push it. If we get a little bit of a cushion, that's fine.
All ready?
Here we are.
Yes, sir.
All right, jury entering.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen, jury, welcome back. First question is, did any of you have any discussions related to the case, do any research related to the case, or be exposed to any reports of the case outside of the courtroom during the break? All right, no hands. Thank you all very much. We're going to pick up where we left off. We're going to turn to the state for cross-examination.
Thank you, Your Honor. Good afternoon, Dr. Heidi.
Hi, Mr. Terry.
Now, Dr. Heidi, you would agree with me that people who have suffered far worse abuse than Nicole Nachtman have not killed their parents. Would you agree with that?
Yes.
Okay. And the choice to kill her parents was her choice. She made that choice, correct? You said there were 3 choices she could make. You said she could either kill her mom, be killed by her mom, or kill herself, correct?
Mr. Terry, I think I said the word outcomes.
3 outcomes. So she had 3 outcomes. In her choice, she could make a choice of one of those outcomes in your mind, correct?
Well, let me, if I may, take a moment here.
Well, doctor, just tell me if that's right or wrong.
Judge, I'd ask that she be allowed to answer the question.
You'll have an opportunity on redirect. It's a leading question. It's cross-examination.
So you're asking me, Counselor, if she had a choice, if you're, the answer...
Between those 3 options, those were her choices, correct?
Yes, and I'd like to give an explanation. And the explanation is, if you look at it in the realm of, yes, were there choices? Yeah. But is this an individual who understands or who perceives herself as choices? So why I'm making this distinction is that she's in a hyper-aroused state. In other words, she's really not doing much thinking at all. What she's doing is reacting. So what she's aware of when she's in this panic state and basically very excited, and this is also related to brain development and age. Individuals who are 21 are not equivalent to adults. The brain is not fully developed until individuals are between 23 and 25. The last area of the brain to develop is the prefrontal cortex. So what that means is when individuals are in a highly aroused state, like Nicole was, that they can't stop, think, and deliberate. So that's the distinction I'm making here.
Okay,
She's not saying, well, I have this choice, or this choice. What she's aware of is there are 3 outcomes.
Okay, well, doctor, you were here in that exact same chair giving testimony in the proceeding, correct?
Yes.
And you were sworn in.
Correct.
And in response to a question, because I'm just using your own words, and correct me if this doesn't sound right, or if this doesn't reflect your recollection. You said in response to a question, yeah, it's never changed, and that's what's interesting. It's always been what I would call a delusion, but that her mom would have killed her. And Nicole saw it as 3 choices. Those were your words, 3 choices. She could kill herself, which she considered doing. So she thought about it. So she had a logical thought process. And at one point said she could, sort of chickened out, I think was the word she used. So she could kill herself, she could be killed by her mother, or she could kill her mother. Those were your words, correct, doctor?
I don't know if I said part of what you just said, but if you look further
I can-
in, okay, that's fine, why don't you bring it to me, that would be good. But I also want to say that I do later on say outcomes is the correct one, so I'll find that for you. Yeah, so I have here, and I'm not, you added, I think, something. I said she saw it as 3 choices, and I did say she chickened out, but then I do, and if you'll give me a moment, I may have to look at mine, transcript, but I do come back and say it's more in terms of outcomes.
Okay, well, you can find that,
All
but
right, okay, well, then, because it's an important distinction, and I corrected myself. So,
But at that point in time, though, you're indicating she had 3 choices, and rather than choose suicide because you said she thought about it and she chickened out, so she made a logical decision. I'm not going to kill myself, I'm going to kill my mom.
no, I disagree, Counselor,
All right,
and if you'll
that's
give me a
fine.
moment, and I think I'm entitled to that, to show you where I did correct that.
Dr.
Am I not
Unsure,
allowed to do that,
redirect.
Judge?
Well, I'll allow redirect.
Okay,
if,
because I know I have that in there where I corrected myself on outcomes.
either
Now, I
Kathleen
understand,
can
Doctor,
correct
you want to, but I'm trying to move this, I'm sorry,
it, or
Judge.
give her the opportunity on redirect.
I will, thank you.
All right.
Okay,
I'm just trying to move this along, Doctor.
Right.
So, all
I
right.
understand.
And you also indicated that the mother provided food, clothing, and shelter for Ms. Nachtman as she was growing up, correct?
That is correct, yes.
And the physical abuse you described, you would agree is limited. I think you've said that very many times.
I would agree.
And I'm sure most cases you see the physical abuse is far worse, or at least in these type of cases.
That is correct.
All right. In fact, Doctor, in your report, referring specifically to page 35, you state on the bottom of 35 that the term battered child typically is used in the legal form in reference to a child who has endured extreme physical and or sexual abuse, correct? That's what you wrote in your
Yeah,
report?
that's usually how it's viewed, Counselor.
Correct. And then on page 36, you indicated as well that the acts reportedly perpetrated by Mrs. Deans, however, pale in comparison to the magnitude of physical abuse I have documented in many cases of parasite offenders. If these physically abusive acts were the only ones to which Nicole had been subjected, I would not characterize as a battered child. So as far as the physical abuse, it did not rise to the level of battered child.
I don't think one would make that determination simply on one aspect of that. So you've got to consider the others.
Doctor. You've explained that there were other factors, the physical or the emotional abuse, the psychological abuse. I'm just saying, as far as the physical abuse goes, it's so limited that you would not consider that particularly on its own to be battered child syndrome.
If that was it, yes.
Okay.
And okay.
And the limited physical abuse you noted is all self-reported from Ms. Nachtman, correct?
Yes, that's
Right.
correct.
There's no police reports of any prior violence or any abuse to her, correct?
Not with respect to Nicole.
And there's no statements from any witnesses who observed any physical abuse to Nicole.
That is correct.
Okay, and there's no hospital records, statements from witnesses of bruising, etc. Nothing like that.
That is correct.
And in all that self-reporting, does she ever say that her mom threatened to kill her in the past?
No, Nicole never made that representation that her mother in the past said that. That's correct.
And the stepfather, Mr. Deans, Robert Deans, there's no evidence whatsoever that he had physically abused her in any manner, correct?
That is correct.
Now, you would agree with me then also that Ms. Nachtman is an intelligent individual with at least average or above average intelligence, correct?
I would agree with that.
All right, and I mean, obviously, in order to get into Florida State University, she had to make the grades, she had to pass the courses and do enough to get into college, correct?
I would agree with that.
Now, early on, you indicated that there was reports of child abuse allegations, and that was between Miriam Deans and Robert Deans, right? They were both accusing each other of the various incidents of child abuse from the
You
family.
mean Ron Nachtman? Is
Oh, I'm
that
sorry, Ron Nachtman. I said Robert Deans. You're correct, Ron Nachtman.
Yeah, so I'm talking to, when I said there was acrimony and abuse allegations, the mother was making them against the biological father, and the father was making them against the mother, the biological father. So her parents were making allegations against each other. That is correct.
And that was back when she was 3 years old, correct?
About that, I'd have to check, but in that period.
All right. And the physical abuse that you mentioned, the kicking, the slapping, things of that nature, none of that would rise to the level of criminal child abuse in the state of Florida, correct?
That I can't answer because I'm not an attorney. Now, I can only tell you what you represented, beating and kicking. I don't know as a state attorney if you would charge that. As a clinician, I consider that very serious.
All right. Well, in under Florida law,
Judge, I'm gonna object, that's outside this witness's expertise, what Florida law on whether someone's gonna be arrested or not.
I'll sustain.
Judge, we approach?
Yes.
Doctor, you've given your earlier talking about the physical abuse. Under the child abuse, and I'm going to ask you if you are familiar with this or if you know this, that under the law in the state of Florida, it's not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. Are you aware of that?
I haven't read the statute in a long time, that's true, but where we're maybe disagreeing is on what is reasonable.
Okay. One of the things you said you reviewed were the jail medical records of Nicole Nachtman, correct?
That is correct.
And the jail medical records show no indication of any diagnosis for any psychotic illness. Isn't that correct?
That is correct, yes.
And at the jail, they have doctors, they have people who see the patient, see the people in jail and take care of them, correct?
That is correct.
And she's not being treated or being treated, she has not been treated or is being treated currently for any psychotic illness, correct?
That is correct. She is not being treated. She doesn't want treatment, and she's doing okay in a contained environment.
And she is currently not taking any medication for any psychotic illness, correct?
That is correct.
You talked about the seeing signs, and specifically you mentioned the signs about you're on the right, or your goals are almost met, or something like that, which she took as affirmation. And that came from Joseph Carey, correct? Or did she tell you
I
other
think
stuff?
she said it to me as well.
Well, when she
I
says
can
it,
look through my notes if you want. That's not a problem I have.
well, Doctor, you're familiar with her path of travel during those 3 days, correct?
I believe I am, yes.
Yes, and it's your understanding and belief that she stayed in Tampa until the 21st, until after the murders, before she drove up to Tallahassee.
That is clearly my understanding and her representation from the beginning.
All right. But she, according to Joseph Carey, what she told him was she drove up to Tallahassee where she saw the signs and then drove back down to finish the job. So that was not true what she told him, was it?
That was his, I don't know, if that's what she said. That was clearly Joseph's or Joey's understanding. Nicole said to me that was inaccurate, so that's all I can tell you on that, Counselor.
Okay. With regards to where you were indicating that going through Nicole Nachtman's childlike character and that her inability to function because she still is functioning in a childlike capacity, correct? You were discussing that earlier, correct?
Her perceptions are those of a child, are more childlike, yes.
And it was
correct.
it was your opinion, Doctor, that she would not be able to function in college in that capacity because of her childlike ability.
Well, when I saw her, she was very impaired, and so it was clearly very difficult. And when I saw her, remember, she's in that severe state of mental decompensation. So I could not imagine, and I've never seen a student functioning like that successfully in college.
Well, let me ask you, can a person with the mentality that you're kind of describing doctor a transcript with Photoshop in order to mislead the mother?
Yeah, and again, Counselor, this is very important, and I really appreciate the question. There is a difference between personality development and intelligence. And I'm not saying that Nicole was not intelligent. I'm saying that her way of perceiving the world and thinking is like a child not wanting to get into trouble. Now let me use a quick example because this will make it clearer. And I think it's important. I just want them
If
to
we can, just
understand.
you answer my question. We need to move along, so I'm trying to just
Okay.
move this along.
But I also want the jury to understand. That's
I think you've explained it. I don't think we need an example at this moment. So I'm asking about the child's, and she was able to get us. You would agree that Nicole Nachtman was able to get a storage unit on her own, correct?
she did get a storage
She was.
unit. I don't know if she had help or not. That I'm under oath. I can't tell you that if her friends, because I know Angelica Henwood said something about I thought helping her, but I know she had a storage unit.
Okay. And she was able to travel to London on her own and live on her own in London for an entire
There
semester,
again,
correct?
Counselor, I honestly don't know. She did go to London and she lived there. How her travel arrangements were made, I don't know. So
You would agree, Doctor, that in order to travel to London, you have to get your passport, you have to go through customs, you have to go get your airline, you have to make your exchange at the airport, you have to go fly in, and then you're in a foreign country, you have to learn how to get to your hotel, how to manage your food, how to eat, how to drink. Basically, she did all that for a semester abroad, and you would agree she did that, correct?
no,
For a semester
I would
abroad.
not. What I want to just take exception, she may have done that. I'm only saying, I don't know. I would be surprised if she made all her travel arrangements from everything I've heard. I just don't see that happening. I think her mother would have been involved in that. Usually schools, when they go and you study abroad, you just don't go on your own. There are provisions made, there are dorm rooms booked. So you're making a lot of assumptions. You could be correct, but my experience says that that doesn't fit with the person I know and my experience as a college professor, that you just willy-nilly send these kids over to London and they fend for themselves. That has not been my experience, Counselor.
All right, but you've not heard anything from anyone that there were any problems with her trip to London, that she had trouble meeting her plane, making her connection, getting through customs, getting her luggage there, any problems with any hygiene while she was in London, any problems getting her food, getting fed, doing what she needed to do, her classes, getting to her classes, her grades were good then. There's no indication of any problems with her in London for that time period, correct?
I can't agree with that totally. She did tell me that she wasn't eating properly, she didn't have a food plan, so she'd go on occasion to get free food, she'd go to Subway, so she wasn't eating real good meals. She did tell me she showered, and she also told me she felt the sense of freedom there. But typically in a situation like that, when you're abroad, there's going to be a containment for college students so they are successful. There's going to be some structure, Counselor, is what I'm saying.
Well, and then let me get closer to the time in question here. She was able to fill out a housing application on her own, which apparently she's been doing for a while because her mom, according to the testimony we've heard, never came up to help her move in, so she was able to get to class or get to school on her own, move in on her own. When it came to the housing application, granted, she was late, so that was the problem, and that's obviously the impetus for the whole thing.
Judge, I'm going to object to the form of the question. I think it's 3 in 1.
Let's break it up.
I'll bring it down to one thing. She was able to take care of that situation, the mess she had created for herself, get the housing application in, filled out, get it approved, communicate with Florida State, get the money to Florida State, scan in.
Let's
Form
break
of
it
the
up.
question.
Judge, I'm going through the list of things she did, and I'm asking her if she was able to do all of that.
Well, it's compound if you want.
All right, I'll go through each thing, but that's going to take a while. So she was able to get the housing application she needed, correct?
You're talking about subsequently?
Correct.
I would think so, yes. The evidence suggests she borrowed the money and apparently got the room.
Correct. And she filled out the application, she got it in, she scanned it, however, she emailed it, correct? You've
As
seen
far
the
as I
emails.
know, I haven't seen it, but she did get the room. I'll agree with that, yes.
The things that she said her mom said to her, specifically the overweight, skank, retard, those things were again self-reported, correct?
That is correct. I don't think I heard anybody say they heard that language directed towards Nicole. They heard language like that in reference to them, but not to Nicole.
Now, you mentioned earlier that, and it was, I hadn't heard it before, but that she attempted suicide with pills. Is there any evidence of that other than what she told you? I mean, is there any evidence of a Baker Act, a hospital stay, anything that where there was medical intervention needed?
I did not see anything. That is self-reported.
Okay, so that is a self-reported. Now, also earlier, doctor, you were kind of describing her sudden grade drop, and you seem to constantly equate irresponsibility with drinking or smoking, and that's usually or is the reason why people's grades drop and they fail to succeed in college. But there's other types of irresponsibility that causes grades to drop. Would you agree?
There could be.
Someone could just plain be lazy and not want to go to classes and do the work that needs to be done. Would that be accurate?
I would agree. That could certainly happen.
And someone could just be, you talk about drinking and smoking, someone could just be, as you claim she may be, addicted to her computer, enjoying her computer, wanting to be in that world, wanting to type and not doing her classes, but rather would stay on the computer. That could be a reason why her grades were dropping as well, correct?
Well, I would agree that that's what happened. The flight into fantasy, yes.
Correct. Now, you administered 2 tests that she got some high scores on to support a diagnosis of PTSD, the trauma symptom inventory and the dissociative experience scale. Now, both of those tests they're both self-report instruments, correct?
That's correct.
And so Nicole could magnify those, correct?
That's why I discussed the validity scores. I had 8 of them, and what they showed is that she was not what's called faking good or faking bad. They were accurate. Now, those were with respect to the TSI-2. That's very important because you want to know that they're reporting accurately. So the test builds that in. Now, the DES, the Dissociative Experiences Scale, does not have a validity score built in. However, this is important, her results were completely consistent with the trauma symptom inventory results. They were consistent with what the school had reported, was in the school records. They were consistent with what she had reported. They were consistent with what her college friends had reported and what the family had reported in terms of the dissociation. So you always want to look for that corroborative data.
I understand. Now, doctor, as part of the material you looked at, did you ever get the email exchanges, or I'm sorry, text message exchanges that took place on Nicole Nachtman's phone? Did you ever review those?
I saw some, I think. I'm not sure. If you could tell me what you're referring to.
Well, specifically, doctor, I'm referring to all of them because there's a number of exchanges between the defendant in this case and the mother, Miriam Deans, and I wonder if you had a chance to review those exchanges between them and if you have any opinion about that.
I'm not sure which ones. When you say extensive, I did see some right around the time of the shootings with the mom appeared to me be checking in. I don't think I saw extensive email contacts between the mother. I think I saw a few. That's my recollection, counselor. And that would have been around the time of the incident.
Now, I'm going to just point out a few of these and ask if it agrees with your opinion of Nicole Nachtman and the relationship she has with Miriam Deans. And so I'll, and again, doctor, if you tell me if you remember these, because I don't see anywhere in your list of stuff that you had reviewed that you had said you reviewed these. Specifically going to the top of page 379 is a text received from Nicole from Miriam Deans, her mom. And it says, "Sorry, honey, we'll get it to your bank tonight." And then down here on the bottom is the response from Nicole Nachtman, "No worries." And then she also sends, because everything that says sent went from her phone, she says, "No worries, take your time, just mainly no, low, nothing serious, And then the response back from Miriam Deans, money in the bank. Let me know you got it, and let me know if there's more problems with the roommate. You see those?
Yes.
Did you review these texts?
I had not seen those.
And on page 392, again, text between Nicole Nachtman and Miriam Deans. And then here's where she says, no, that is just when classes end. And then the response from Miriam Deans, no seats on Saturday, just checked. And then the response from Nicole, just let me drive down. And her response, I said no, Bob says the car needs maintenance, so besides safety, I don't want you stranded. You review those in the course of your...
No, but are those in reference to the spring break? Is that what it's about? I had not seen those.
No, it appears that she's trying to get down and her mom is concerned for her safety in driving the vehicle, correct?
With a little bit that I saw, that's the inference I would make, and it seems like it's around spring break. I'm just trying to put a context in, Counselor, so I can understand it. That's
I'm just asking for you to review. Do those
No, I
texts,
did not see those.
do those texts sound like the mother you've been describing and the relationship that you've been describing of a woman who's scared of her mother to death and a woman who has a horrible relationship with her mother, or and a mother who doesn't care about her daughter? Or does it sound...
Objection to the form of the question?
Well, rephrase, but first put the exhibit number on the
Yes.
record, please.
Sorry, Your Honor. That was State's Exhibit number 70.
Okay. Go ahead and rephrase the question.
Judge, I'll move on.
I can respond to the question.
It's okay. Let's move ahead to the murders in this case, both the Robert Deans and Miriam Deans. Actually, let's go specifically to the murder of Miriam Deans, because that's where your testimony regarding battered child syndrome applies as far as her. It only applies to her case, correct? You understand that?
I do. I understand that's a court ruling.
Right. So, and it applies to the self-defense instruction. And are you aware of the self-defense instruction?
I'm aware of the self-defense instruction in general. I think I know Florida law, but I haven't looked at it in a while.
Now, I want to go specifically to what Ms. Nachtman told you about the moments before she shot her mother. Can you go through that, what she told you about that?
Yes. What she said was that she was just trying to decide basically what to do. She was thinking of, and I want to go back to that time, so that's why I'm pausing.
Just if you can, just to the point where she decides to leave the house when her mom comes in, she chickens out or whatever and goes out the window. Describe what Nicole described to you, how the actions occur.
All right, Counselor, I'll answer your question,
Okay.
but I want the moment to think about it because it's
That's fine.
important to recollect my thoughts.
Absolutely, you can have that.
Thank
sure.
you. All right, so what she told me was that she's trying to basically, she's in this state of panic. She talks about, should she tell her mom, and she's kind of thinking that she'd tell her mom, and her mom, she somehow thinks that her mother can fix this. And that she's saying, well, she'd tell her mom, and what she's concerned about, as she says, is that her mom will, I use the word coup, but will say to her, sweetie, you can tell me anything. And then she said, I'll tell her what happened. And then she uses the expression, I'll sing like a canary. And then mom will take the gun if she has it. No, she'll talk me out of the gun, and then she'll shoot me. So she's trying to decide, should she take Mom in? She's wrestling with, she says at one point, if Mom can't keep a secret, and she's talking now about the iPad, and she's saying, like, if Mom couldn't help me with something like that, can I trust her to help me with something like this? And she's talking about the death of Bob.
All right, Doctor, maybe I misstated my question. I guess.
I thought you wanted to know what she was thinking, Counselor.
No, not what she was thinking. That's why I said I must have misstated, so forgive me. Let me rephrase it, okay, so I can say it exactly right. At the moment before she killed her mom, describe the actions that were taking place, what she observed, what she decided to do at the moment she decided to do it, what her mom was doing. I want to hear that at the moment she shot her.
All right, well, what I was saying was relevant, at least in my thinking, because it talks about what she's doing. So she's having this kind of thinking process with herself. Then she's surprised. It's like her mother, she hears her mother in the house. That's what she reports. And it kind of caught her off guard because she didn't expect the mother. And she panics because now it's that moment where she could talk her mother in or whatever. And she says she panics and she goes out her, I believe it's her bedroom window. And she runs, she takes the gun because she's afraid that her mother, as she reports, will shoot her. She runs to what I presume is the front of the house where the driveway is. She runs unexpectedly into the mother. Apparently the door of the house is open. Her mother may have been in, but she runs into the mother. The mother says, reportedly again, excuse my language, "What the fuck are you doing here?" And Nicole said, and she shot her. And I think she said her mother screamed or yelled or both, and she shot her again. And a total, I believe, of 3 times. So that's what she reported to me.
All right, thank you, Doctor. And so she never indicated to you that the mother made any aggressive actions towards her, in any sort of movements towards her, in any way physical?
She did not report that her mother in any way was physically aggressive. She was verbally aggressive, but that's nothing physically aggressive.
And so she reported no physical assault or any aggressive movement towards her at the moment she shot her mother?
That's my understanding.
Now, Doctor, I believe you and I might have a little difference on this, but I want to go straight to what you stated to me back on January 9th of this year, of 2019, almost 4 years since the murder, in which I asked you, this was a hearing regarding the battered child syndrome. At one point in the hearing, because your report does not indicate that you made any sort of a diagnosis of insanity, does it?
No, I wasn't. I don't recall being asked to do that, but I did not make a diagnosis of insanity in the report.
Okay. And at one point in the proceedings, when I'm talking to you and you're giving me a description of her schizotypal personality disorder, and I'm going to read these lines to you and your responses, and then we'll get into that. But I asked you, and this was a question from me, but doctor, you are not opining, and correct me if I'm wrong, but I've read your report. You are not opining that she did not know what she was doing at the time, and she did not know right from wrong. And you responded, that's correct, I'm not opining that. And I said, so she would not fit under the McNaughton standard of insanity, correct? And you said, that is correct.
Yes, and then I said in reviewing the jury instructions, which I've done subsequently, that's where I saw or its consequences. And that's why I have come up with a different conclusion. In my report, and I can point to it in several places, I do talk about not knowing the seriousness or appreciating the consequences. So that is why there appears to be a change. You were on McNaughton, and that's what I answered, and the jury instructions are broader than that. And your question, Counselor, specifically says right from wrong, and I have the page number 2.
Doctor, I've heard it, but let me ask you this, okay? You've now told the court or the jury the McNaughton standard, but it's true in fact that Florida in these instructions were based on the McNaughton rule, correct?
Absolutely, I agree with that.
And citing to a Supreme Court of Florida case, and I'll give you the case site for you so you're aware of it. Patton v. State, 878 Southern 2nd, 368, a Supreme Court of Florida case from 2004. And this is from the Supreme Court, in which they stated, the legal test for insanity in Florida in criminal cases has long been the McNaughton rule.
Judge, is there a question?
I'm going to read this to her, Judge, and ask her if this is what she understands the law to be.
He's now Judge, can we approve?
Yep.
So, Dr. Heidi, I'm going to go ahead and show you this case, and specifically Head Note 7. And I'm asking you to read that paragraph. Right there.
You just want me to read those like 2 or 3 sentences or the whole paragraph?
Just that paragraph.
Oh, all right, hold on. Okay.
All right. Doctor, does that paragraph explain what the McNaughton rule is in Florida?
Yes, but that's not how you phrased it to me, Mr. Terry.
All right, but it does, doesn't it? And according to the Supreme Court of Florida, the McNaughton rule states consequences in it, does it not?
Right, but that's not what you asked me, sir. And I went by your representation, and often the McNaughton rule doesn't have or its consequences in the first prong. So that's
the
what I'm saying.
McNaughton rule changes?
No, but the point is that, and again, I'm not saying that it changes, but oftentimes it's phrased as didn't know what you were doing, or if you didn't, or you did know that you did know it was wrong. So I have seen it represented that way. That is my understanding of it, or my recollection, let me put it that way. The way you said it to me, and if you look at what you said, was abbreviated, which is what I just referenced to you, of what they were doing or it was wrong, and I agreed on that premise. The only thing we're having a distinction now is you are inserting based on the Supreme Court or its consequences. That's what the jury said, and that is not what you asked me. I put in my report consequences, so that's what I'm making reference to.
Doctor, I said the McNaughton standard, correct?
You did, sir.
All right.
But you
It
didn't
was
state
followed
it
in
correctly then, if that was your understanding of it. That's my point.
Have you ever been hired as an expert on insanity in the state of Florida?
Yes.
All right. So when I was asking you those questions, you didn't ask me, well, are you referring to Florida insanity, McNaughton standard that's different, that doesn't say consequences? You didn't ask me none of that.
I went by what you said, counselor, and what you specifically said was she didn't know what she was doing or it was wrong. And that's what I answered. You said under the McNaughton, I assumed you were quoting it correctly, and so that's what I went with.
And according to that Supreme Court decision, McNaughton states consequences,
Asked
correct?
and answered?
Right. And I answered.
Objection, asked and
Let's
answered?
move on.
So let's get into that statement here, Doctor. You indicated she had a mental infirmity, disease, or defect, and because of the condition, she did not know what she was doing, and you said no, she knew what she was doing. She knew she was shooting people, correct?
I think she knew that she had a gun and that she was shooting them, yeah.
Okay. And then your quibble is with the consequences word. What is the immediate consequences of shooting a person?
Well, normally you would think with a rational person that shooting somebody would lead to physical harm, possibly serious injury or death. When I was looking at consequences, when I got the reviewing the jury standard or the jury instructions, I was also considering, did she consider the seriousness of this offense appreciated? And that's why I said, if I take into consequences, and I already testified, she had no understanding of how serious this was, and for almost 2 years, she kept thinking that her mom, in fact even longer than that, could influence the outcome, which kind of leaves me wondering, again, did she quite get, her mother was dead, and it was, I have it right in my notes, and it's in the report, when she finally said, my mother is dead, but still kind of thought her mother somehow could impact the outcome. So that makes me kind of think, does she really get this whole thing about consequences?
So, Doctor, you're extending the word consequences from the immediate action. So the action of doing the shooting, the consequences of shooting someone are what, Doctor? Just the immediate consequences of shooting a gun into a person.
To a rational person, the immediate consequences would be serious, I mean, if you hit them, serious physical injury or death.
Do you believe that Nicole Nachtman knew when she shot that gun into the back of Robert Dean's head, she knew that she would kill him?
I don't. Should she have known? Did she know? And I'm only saying this because I don't know that she is. Again, you have to remember this is somebody who's panicky. When she does shoot him, she sees he's on the floor. And she even considers for a minute when, I don't know if he's making noise or what he's doing, but she's even considering he's faking. So again, it leaves you with that question. It's almost like, again, a child.
Well, she knew that she could put the gun to her head and kill herself. She knew that when she shoots a projectile, she could kill someone, correct?
I would say yes, in that sense.
Okay, so, in shooting a gun, you know that you can kill someone. Those are the direct consequences of shooting a gun at a person. Would you not agree? Direct consequences. We can sit here and discuss consequences beyond all the way till the moon. But the direct consequences of that action of pulling the gun is to kill someone. Correct?
If you're saying direct to a rational person, yes, it would be to cause serious injury or death. I'm answering your question.
Okay, I'm not saying rational. Did she know that when she shot him, she was going to kill him? That he would die, or most likely die. She's a Florida State student. She watches horror movies. She's familiar with guns.
Objection to the form of the question. He asked the question and didn't let her answer.
Did she not know that in shooting this man, she would hurt him or kill him?
In some respects, it's hard to know what her thinking is. If you're saying natural consequences, I think you said are direct, the answer you would think would be yes, she's panicked and she shoots him. So exactly what's going on in her mind, I don't know. But that's what I meant. That's the only reason that I'm hesitating there.
All right. Well, Doctor, you said all along that in her mind she had 3 choices.
I said 3 outcomes, and I did find it for you. Now,
Okay.
I hope I didn't
All right,
lose
3
it
outcomes. 3 outcomes here, that's fine. Either
again.
way.
It's on page 239, and that's when I corrected myself.
Okay.
So I just want to make that distinction. It's not like she's sitting there and going, well, I could do this, and deliberating and going, or I could do this. It's sort of like she's aware of it, and you've got to remember she's in a when I say hyper-aroused state, she's panicked, she's terrified, she can't figure this out, and you can't separate that from the mental illness.
All right, Doctor. So, going back to the original question, in speaking, in having heard your options, or what did you call it? The
Outcomes.
She knew that one of the outcomes was killing her mother.
That could occur, yes.
Okay. And that's why she had the gun.
Well, I can tell you what she told me. She told me she had the gun because she was afraid her mother would kill her. She took the gun so her mother could not use it against her, and she jumped or went out of the window and ran into her mother.
So again, my original question. Did she know when she shot a person that she could kill a person? Simple. You take a gun, you shoot someone, you can kill that person. Would you not agree that she did know that? Simple fact. I mean, just by the fact you said she's of average intelligence, she would know the purpose of a gun and what it can be used for, correct?
You're saying based on intelligence, yes, of course she would know that.
I'm going to have a moment, Your Honor.
Yeah.
There are no further questions.
Redirect.
Mr. Terry just asked you questions about whether there were any witnesses to the physical abuse that Nicole reported. Do you recall that question?
I do.
And in typical battered child cases or abuse cases, do abusers typically batter their victims in front of a room full of people?
Not typically. I mean, on occasion it happens with other family members if they're present in the home, but nobody was present in this
And
home.
after Nicole was about 3, isn't it in fact true Joey, Kevin, everybody's out of the home by that point?
Clearly Joey's out of the home.
Do you
I
recall what
think-
year Kevin passed away?
It was, just give me a minute, it was around 2004, but I believe he lived with the father, who's a different father, that's Joseph's father, Mr. Carey. I could be wrong there, but I think he did live for a period with Mr. Carey.
Mr. Terry asked you whether this was the most severe case of physical abuse that you'd ever seen, and you indicated that most cases you worked
Objection,
on,
Your Honor, that's not the question.
that this was
Well,
not.
I will instruct the jury to rely on their own recollection. Rephrase.
Mr. Terry was referencing that this case was not one of the most severe cases of abuse that you'd ever seen. Is that correct?
That is correct.
And you in fact
Of
documented,
physical abuse, yes.
and you in fact documented that that was in fact true previously, correct?
Yes, it's in my report.
However, in your 30 plus years as a college professor, have you ever seen anyone so impaired at the age of Nicole Nachtman at the time of these offenses than you do in this case?
I would be hard pressed to say that I have. And now you have to remember, Nicole is not only 21, she's close to 25.
Mr. Terry asked you if anywhere in the jail records, jail medical staff ever diagnosed Nicole with any type of psychotic disorders, and I believe your answer was no.
Not psychosis per se. In the record, there is some reference that she reported when asked the auditory hallucinations, the screaming, and that was on admission. She did report that.
How many total hours did you spend with Nicole Nachtman over the last 4 years evaluating her and doing clinical interviews of her?
It would have been about 35 hours. Now that's over the course of 4 years, or almost 4, 3.5.
And is your diagnosis of schizophrenia, your belief that she was suffering from delusions and that she was psychotic on the date of the offense, all based on you spending those 35 hours with her in addition to the records and the data that you've reviewed in this case?
Yes, and it's also based on, and I want to make this part of the record, a very careful analysis and going back through all those clinical interviews. Because when you give a diagnosis, a clinician gives a diagnosis of schizophrenia, it's a very serious diagnosis. So it's important to have the data that support it. The psychotic break was always evident to me and I believe to others. But to establish that diagnosis, you need to have evidence of those symptoms, and we talked about that. I went through where the delusions are ongoing, the signs, the referential signs are ongoing, the problems with the disordered thought and speech are ongoing, the problems with the hygiene are ongoing, the problems with forming relationships are ongoing. The test data is showing that she has problems with relationships. So that's all very important, Counselor, Mrs. Hersey.
Mr. Terry also asked you about the tests that you administered to Ms. Nachtman, one being the trauma symptom inventory. And you in fact indicated that that test specifically has validity scores that indicate Ms. Nachtman was not faking when she was responding to those, despite that having been a self-report test.
Yes, and that's very important. Again, that's a very good test, very well respected. So we have 4 indications on that test alone that she was, meaning there are 2 validity scores, faking good, faking bad on 2 tests, so 2 times 2 equals 4 measures of validity, which would say she's not faking, malingering, lying. She's reporting her symptoms accurately.
Mr. Terry showed you 2 text messages from Miriam Deans indicating that she was possibly putting money at some point in Nicole Nachtman's bank account. Do you recall those text messages he showed you?
Yes.
Does the fact that Miriam Deans was putting money in Nicole's bank account change your opinion as to whether she suffered psychological abuse at the hands of her mother?
No, absolutely not.
Do 2 text messages indicating that her mother put money in her bank change your opinion as to whether you think she suffers from battered child syndrome?
No, not at all.
And in fact, did you testify earlier today that there's no dispute that Miriam Deans bought things from Nicole, provided shelter, sent her to college, bought her a car, correct? You never disputed that fact.
No, and I would just add that that came up repeatedly in my interviews, that the mom did buy her stuff, but Nicole felt she held it over her, held it against her, and she got to the point she didn't want her mom to buy her stuff anymore.
Does the fact that Miriam Deans was providing food, shelter, and a college education to Nicole Nachtman in any way diminish the abuse she suffered at the hands of her mother?
No, not at all.
Doctor, I want to give you the opportunity to tell the jury at that hearing Mr. Terry asked you about as to what your testimony was with regard to outcomes versus choices. You tried to do that several times, so I want to give you the time to do that.
This is on page, let's see if I just made this, page 239. And Mr. Terry's correct, I did use the word choices. Then I said, this is about 2 paragraphs, probably could say she doesn't see herself as having choices. And so she would say that the killing of her mom just happened. She also said the same thing about Bob. Also said the same thing, I believe, to Dr. Lazaro. Okay, going back to my testimony. So you and I know there were choices. I'm talking to Mr. Terry. So you and I know there were choices, but when you came down to, I guess what I'm saying here, she saw there were 3 outcomes. So she wasn't deliberating well. Here's what I could do. I could, meaning like, in terms of making a conscious decision, but clearly there were 3 outcomes. And that's really what I want to emphasize, that she recognized and believed in.
And is that testimony about outcomes consistent with what you've told this jury today?
Absolutely.
With regard to your opinion on consequences, the insanity jury instruction, do you recall how long your testimony was at that hearing we've referenced in January of this year with regard to battered child syndrome?
My recollection is it was about 4 hours.
And in those 4 hours, the only 2 questions reference your thoughts on McNaughton or insanity.
Judge, at this point we approach?
Yeah.
Dr. Heidi, that hearing back in January you indicated a moment ago was about 4 hours long?
I think it was at least 4 hours long.
At least your testimony.
I think so.
And you'd agree that the
Yeah, at
focus
least my testimony, right, because it did go all day.
and you'd agree the focus of that hearing was the battered child syndrome and the history of abuse that Nicole had endured.
That was my understanding.
And the questions that Mr. Terry asked you about McNaughton and the wrongfulness of Ms. Nachtman's actions, as we've noted in his questioning to you, was about 2 questions in that 4-hour hearing.
Yes.
Were you deposed by Mr. Terry in this case?
No, I was not.
And a deposition is an opportunity for lawyers, I'm sure you've been deposed in your history, to ask questions and have experts or people expound on things, and that was not done, correct?
Correct.
And in
Yes.
fact, you authored a 52-page report in this case dating back to 2018.
That's correct, yes, October 2018.
And again, the report does not address insanity, but the focus of the report was the battered child syndrome and the abuse that Nicole Nachtman endured, correct?
That's absolutely correct, yes.
Can I approach and borrow that jury instruction again?
Sure,
Yes.
if I can find it. I might have misplaced it. Give me just a moment. I'm sorry. It might be right here. No one read it. Here it is, Mrs. Hersey.
Thank you.
You're welcome.
Your opinion as to prong one has always been that Nicole Nachtman suffered a mental infirmity, disease, or defect, correct?
Yes, from the
And I
very
think
beginning.
the important thing to note about this instruction is the very first sentence. Can you read that for the jury?
Yes, here it is, I'm sorry. A person is considered...
An issue in this case.
Yeah. Oh, okay. An issue in this case is whether Nicole Nachtman was insane when the crime allegedly was committed.
So this instruction specifically deals with at the time of the offense, correct?
Correct. That's what I'm reading, yes.
And you have never wavered on number one.
She has a mental infirmity, disease, or defect. No, I always said that.
And so when you go to number two, when you answered Mr. Terry's question at that hearing about McNaughton, is it fair to say that you were referring to prong B, that Nicole Nachtman knew that murdering somebody was wrong?
Yes. However, Mr. Terry did say he didn't give me the whole instruction, is what I'm saying.
Okay. And so
Of
now,
A.
as you sit
Yeah.
here today after having reviewed this instruction and knowing Nicole Nachtman as you do, having spent over 35 hours with her, have you always believed that she did not understand the consequences of what had occurred in August of 2015 when she killed her mother and her stepfather?
Yes.
I can have a moment?
Yes.
Thank you, Dr. Heidi.
Free cross?
Thank you, Judge. Dr. Heidi, Ms. Hersey-Fulgara just mentioned that I only asked you 2 questions at that hearing regarding insanity, correct?
That's my recollection, Counsel.
Right.
I can go check it. I got it.
But in fact, at that time, on January of 2019, insanity was not even an issue in this case. Would you agree with that?
I would agree that at least as far as that hearing that we were focusing
So
on.
the fact that I only asked you 2 questions would make sense when insanity was not even an issue in the case at that time, correct?
I don't know that I could determine that.
All right.
That sounds more like a legal question to me.
All right, thank you, Doctor.
Any direct?
sir.
All right, may this witness be excused.
Yes.
And by the state?
Yes, sir.
Thank you. May we step down to be excused as a witness?
Thank you.
Oh, she had a box. Yeah, you can come
Yeah,
on
I got
down,
a lot of
absolutely, and help her
stuff. Thank you.
carry her stuff.
Okay. Thank you, Judge.
Just do we, I don't know, take a brief recess.
Do you need a brief recess?
No.
All right.
Took me a minute to clear out of my stuff.
As soon as we clear the witness stand, I'll allow you to call your next witness. It's all right. Don't. Ladies and gentlemen, if you want to stand up and take a stretch break while they're doing that, you're absolutely welcome to do that.
Thank you very much, Judge.
Watch your step on the way out. All right, I believe the defense is ready with their next witness. I know it wasn't much of a stretch break and it wasn't a break where you get to go back into the jury room, but we're going to try to keep moving. Unless somebody, if you raise your hand because you absolutely need a break to go out of the courtroom, don't be shy, let me know. All right, I'll ask the defense to call your next witness.
The defense calls Dr. Charles Ewing.
Dr. Ewing, if you'll come forward to be sworn, sir, wherever you're comfortable, if you'll raise your right hand, thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, doctor. If you'll follow the bailiff around the branch that leads up to the witness chair, please watch your step. When you get to the chair, go ahead and have a seat. Make yourself comfortable. That microphone is adjustable. It looks like it got moved up. You might need to bring it down, and if you've got any stuff you need to unpack, you're welcome to do so.
The chair adjust?
The chair does adjust, but I don't know exactly which lever it is.
Okay. Thank you, Your Honor.
I've seen other witnesses figure it out, though.
Can you introduce yourself to the jury, please?
I'm Charles Patrick Ewing.
Doctor, let me have you bring that microphone down because some of the jury do have
Sorry.
sometimes it's not amplified.
My name is Charles Patrick Ewing.
Tell me what you do for a living.
I'm a forensic psychologist.
Tell me what a forensic psychologist is.
I evaluate individuals who are involved in primarily criminal litigation, but some civil litigation. In civil litigation, mostly involved with evaluating plaintiffs who claim that they've been injured. And in criminal cases, I'm involved in evaluating criminal defendants. My practice has gone on for 30, 40 years. Most recently, most of the work that I do is court-appointed work. I evaluate competency for the courts in, I'm not sure what judicial district it is, but it's Collier County, Lee County, Henry County.
Kind of down in South Florida.
Yes.
Can you tell the jury your educational background in psychology?
Yes, I have a bachelor's degree in psychology from Syracuse University and a doctoral degree from Cornell University.
In what year did you receive those degrees?
1971 and 1975.
Do you also happen to have a law degree?
I do.
And
Yes.
where did you get a law degree from?
I graduated from Harvard Law School in 1983.
And what was your purpose for going to law school? Just you're obviously you're get your psychology degree. What was the added degree in law school for?
Well, I've been a psychologist for a while, and I was a clinical psychologist. I worked in a hospital, worked in the emergency room, and I was the director of a children's program in the hospital, mental health center. I got involved in a lot of child abuse cases, mostly not as an expert initially, just as a reporter, mandated reporter. I saw a lot of child abuse, reported it, and ended up testifying, and then was at one point called on as an expert witness to testify in a child abuse case. I testified for the state, and after that, I got more and more calls to testify in court, and I asked attorneys, asked the judges about going to law school and what they thought about it, and they all told me not to do it. And so I did it. But seriously, I thought that I wanted to pursue a career as a forensic psychologist and do more work in the courts. And since then, I've been a forensic psychologist since 1983, and also since 1983, I've been a professor.
Now, is it fair to say that despite getting the law degree, I guess to kind of educate yourself in forensics, your primary focus or practice has been in the area of psychology?
Yes, yeah, I haven't done much in the way of legal practice. I did a little bit early on, and also at the end of law school, I had the opportunity to do some prosecutorial work, but I haven't really practiced law. I am admitted to the bar in New York State.
And the forensic psychologist you said you became in 1983, is that correct?
I would say, yeah, that's when I graduated from law school. That's when I would say from then on, pretty much all the work that I've done as a psychologist has been forensic psychology.
Now, as it relates to the areas of child abuse or battered child syndrome specifically, you had indicated you treated patients and worked in a hospital and dealt with victims of child abuse, which is kind of what piqued your interest. Can
Yes.
you tell the jury about any publications, literature that you yourself have authored or been a part of in those specific areas pertaining to child abuse or battered child syndrome?
Well, I've published 11 books and 60 to 70 articles and papers. I think probably a third of those deal in some manner with child abuse, child neglect, intrafamilial violence. Two of the books, three of the books deal specifically with one is called Kids Who Kill, one is called When Children Kill, and the third one is called Fatal Families, which deals with all kinds of homicides within families. Adults who kill children, children who kill adults, adult children who kill their parents, sort of runs a gamut.
And as far as those publications, the books, the articles you wrote, all dealing with the topics that you just mentioned, are those all, I guess, recognized within your field?
Yeah, I would say a number of my books have been published by Oxford University Press, and others have been, they've sold well. I don't know if that counts. People in the field have read them. They've been well reviewed and cited.
With regard to your practice, do you practice in other jurisdictions besides Florida?
Yes, I'm licensed in New York and Florida, and I've testified in about a dozen other states, and I've done work in maybe half a dozen other states where I did not testify but did forensic practice.
If you know, about how many times do you believe you've testified in your career in the area of psychology, child abuse, and or kids who kill parents?
Oh, about those issues in particular, I'd say maybe 50 times.
Throughout the country?
Yes.
Judge, at this time, if the state has any questions of Dr. Ewing.
No questions.
You may proceed.
Dr. Ewing, when were you retained in this case?
I think it was sometime last year or early this year. I don't remember the exact date.
And what materials, and again, generally, were you provided and did you review in preparation for your work in this case?
Yeah, I have a list. The defendant's jail records, the child abuse allegations from when she was young, Florida Department of Children and Family records, again, when she was young. There was a big chunk of material that was labeled discovery, which included police reports and other items related to the homicides. Then there was a Texas family court file dealing with custody and visitation litigation. I saw, I don't know if it was complete, I don't think it's complete, but I saw a number of Nicole Nachtman's educational records. I saw a visitation this is a video of a visitation Nicole Nachtman had with her brother, video visitation after she was arrested and incarcerated. I saw the depositions of Angelica Henwood, David Lair, Eric Lair, George Lair, Hunter Lair, Jackie Roman, Laura Hessemer, and Joseph Carey. I reviewed videotapes of Dr. Lazaru's evaluation of the defendant. I reviewed a video of the defendant while she was in custody of the police, a video of a visitation she had. I may have already said this on 9/8/15. That was with her brother. Video of the defendant's visitations with her father. And you asked me what I used for my opinion, or
No, just what you reviewed. First materials.
Okay, those are the materials that I reviewed. After I gave you my opinion, I reviewed a 52-page report by Dr. Heidi.
Okay, so just so we're clear, the initial discovery materials or case materials you reviewed, and then interviewed Nicole Nachtman. You formulated your opinion as it relates to that, and then later were provided Dr. Heidi's report, Dr.
Yes.
Lazaro's deposition, evaluations from all the doctors involved after you had rendered your opinion.
Well, there was a deposition of Dr. Lazaro. I don't believe there was a deposition from Dr. Heidi,
Correct, just her report.
just her report.
When did you evaluate Nicole face to face, and if you can explain to the jury what you do when you have a mental status examination like you?
Yeah, I saw her on April 8th of this year. What I did was to take a detailed family, psychosocial, educational, occupational history from her mental health history, and I did a fairly standard mental status examination to determine what, if any, mental illnesses she was suffering, what, if any, symptoms she had experienced. And then I specifically questioned her at length about the events leading up to the homicides in this case and her state of mind at the time of both homicides.
Now, in the materials that you mentioned you reviewed, what impressions did you have from Nicole's childhood records, the family court file, the custody battle, and things like that that would be relevant to your opinion today?
Well, she got off to a rocky start. Her parents, almost from the get-go, were litigating over custody, over visitation. One parent said the other parent sexually abused her. The other parent said, no, you sexually abused her. They were battling in court. There were just hundreds and hundreds of pages of documents, complaints on either side, court documents, or court orders, temporary court orders. There was a lot of litigation. It was clear that she, at least for the earliest years of her life, there was a lot of family turmoil and aggression, not physical aggression, but well, there was some between the parents, but not toward her. But there was a lot of turmoil and I would say verbal aggression going on.
Why is that of significance in a case where there may be allegations of child abuse?
Well, because you're talking about.
In the early years, why is that so significant?
Well, it was significant to me because there are allegations.
Wait, time, hold it.
I'm sorry.
Do you want to break, go to the restroom?
All right, I need a restroom break, so we will absolutely take a short break. Do not discuss the case amongst yourselves with anyone else. Do not do any research related to the case, and avoid any exposure to any reports of the case outside the courtroom. We'll just take a very short break until anybody who needs to send you all back there. Anybody who needs to use the restroom, use the restroom. We'll bring you back. All rise for the jury. Jury is exited. Everyone may be seated. Doctor, it's going to be a short break. You can step down if you want. If you want to use the restroom or anything, you're welcome to sit there.
I'm good. I'll just
if
relax.
you like. Yeah. If you're comfortable there, you can stay there. We're still 5:45?
Let me ask Dr. Ewing about what's